Good morning, Cilna. How are you doing?
Good morning, Ryan. Good. How are you doing?
Yeah, good, thanks. I'm so excited for this morning. It's so nice to have you with us.
Oh,
Um,
thank you.
we've got the Remax family with us and all those that have been invited to join us today. It's super awesome to have you. So I want to start off by saying good morning, good afternoon, good evening to all of Remax SA and to all that are joining us today, wherever you are in the world. Welcome to our Q&A session with Cilna Steyn. And really looking forward to this. It's going to be a nice little informal chat with you, Cilna, and of course we will be looking at the comments on Facebook and YouTube, and we have a couple of questions that we're going to shoot your way, which I'm really excited about.
Even me, I must say, I'm so happy you said it's an informal conversation because I even have my coffee ready. So it's always nice to have a chat with you. And thank you so much. I'm really honored to represent SSLR as well on this. And thank you so much for involving us in the Remax journey. It's really a massive honor for me to be busy with your training and this conversation. Thank you so much for having me.
It's an absolute pleasure, Cilna. And to all that are joining us, please feel free to say hi. Please let us know where you're from, which franchise you're from. It's so nice to have you here. I'll give you a little brief introduction. Cilna's CV is ginormous. It's one of the biggest ones that I've ever seen in my life. So I'm going to give a summarized version of it. Cilna completed her LLB degree at UNISA, after which she was admitted as an attorney in 2007. She's also the co-founder of SSLR, where she began to specialize in evictions. She regularly presents training sessions where she advises groups of rental agents and private landlords on matters relating to landlord and tenant disputes and the broader scope of property law-related matters. She also acts on the panel of experts for the Law Society of South Africa's Legal Education and Development. Sure, Cilna, talk about a mouthful.
I always, when people read that out loud and I have to sit and smile, I'm always like, that sounds like an amazing lady. I should totally get to know her. She sounds like she knows a thing or two. I'm always surprised if I realize it's me. But thank you so much for that introduction.
An absolute pleasure. We have so many agents joining us. We've got Aurelia joining us from Bedford View. We've got Roz from Remax Address Cliff in KZN. How's it going? We've got Kerry Maynard from Remax Masters in Bryanston. B. Barbell from Remax All Stars, Fishers Hill, Joburg. It's so nice to have you here with us. Very cool. Cilna, you've got a captive audience today. The viewership numbers are streaming in. This is really, really cool. And yeah, Cilna, so give us a little bit of background in terms of where this passion came from.
Oh, wow. That was a question I didn't expect, but definitely one of my favorites. Thank you so much, everybody, for watching. So let's keep the story of the passion short. So basically, uh, when I accidentally and really accidentally started a law firm, I was 24 years old. So I had no idea what's going to hit me. And I've just always been entrepreneurial in nature. So the moment I saw, oh, yay, a law firm, that sounds like fun. Let's do it. And I realized I don't want to do general law, just the general practice. I really accidentally, started doing evictions in 2009, and I realized nobody knows how it works, and I love something that nobody can tell me how to do. If I don't know how something works and nobody can easily tell me how something works, I usually enjoy it and dig into it so I can figure it out and understand it. And I had two evictions in 2009, and nobody knew what to do. I have a mentor and a good friend. He was the CEO of the Law Society of South Africa, Nick Swartz. He sadly passed away in 2017. But I always spoke to him and I always asked him, Nick, how do we do evictions? And none of the attorneys in the country at the time really had a good grasp on residential evictions. So I was 25 at the time, and I thought, let me figure it out. It looks like fun. And then the next moment I figured it out. And then the Law Society said, okay, come and train the other attorneys on how we do it. And from there, I developed a good relationship with TPN, and Michelle Dickens and I figured out a lot of things around rentals and evictions. And it was just a very exciting time. And from there, it just snowballed until the 2015. I took over as the managing director in SSLR, and I decided to specialize exclusively, to have the firm specialize exclusively in property law, because I believe to really give the best quality service, you need to be absolutely specialized in your field, especially on something like rentals and evictions, where there isn't a lot of firms in the country completely dedicated to that. And the passion just grew. And then I got into relationships with the estate agents, and I fell in love with this part of the industry. I just love rental agents. And I actually looked at the industry and I realized for a very long time, rental agents were seen as the sales agents that couldn't make it. And that was so sad. It broke my heart. And I realized it's the biggest load of nonsense, because rentals are such an amazing part of the industry. And for an estate agent to have a strong rental book is, in fairness, the actual only sellable or valuable, quantifiable portion of your book, of your business. So this is your business. And it's still seen as like the stepchild of the industry. Well, it was. And I decided not on my watch. And that's where my passion comes from. So I love the rental agents of this country with all my heart. And I think that's why I have WhatsApp groups with all the agents. And I promise you, I only have one phone. This is it. And I have everybody on this phone. And any agent can ask me a question at any time. I do feel a bit like the mother hen of the industry. And that's, I think it's my love for the rental agents, honestly, Ryan, that's keeping me focused and motivated in the industry. And then obviously my deep passion and love for South Africa. And I want to see this country thrive. I do believe it's sitting in our property industry, and rentals is very close to my heart, because I want to make sure that by the time I leave this earth, that South Africa's low cost housing situation and low cost rentals on a stable, proper situation. So we don't have people living in shacks anymore, because that breaks my heart. And so it's actually my bleeding heart that got me into evictions. Did not see that answer coming.
No, I didn't. But I mean, I didn't know answered any better than what you did. And I'm very fortunate to have met you in person. So I could definitely see the passion that lays behind what you're trying to get out there, the holistic approach that you have, the organic approach that you have, especially on the subject. And after I'd sent the email out last week to the network about what we were doing, the amount of replies that I got and the amount of questions that I received, we're going to fire your way this morning. And please, for all of those that are joining us, if you have any questions to ask Cilna, I'll have a look at it through the comments on YouTube and Facebook, and I'll try to get them out there. If I don't get them out there, please send them to me, and I know Cilna will be very, very happy to answer what she can, when she can. So Cilna, let's get straight into it. First question for you. If a property owner gives an individual the authority to manage the property, does that person need to be a registered estate agent?
Look at my first lawyer answer. That would depend, Ryan. Okay, the easy answer is actually, so since the 1st of Feb with the promulgation of the Property Practitioners Act, everybody's been talking about what is a property practitioner, who needs an FFC. And once again, I think that is why the industry received the blonde to answer the questions, because I have a way of simplifying things in my head where I can just, give a simple answer and everybody's on the same page. So the simple answer is, if you are managing a property on behalf or trading in any way with the property on behalf of a third party, you have to be a registered property practitioner with a valid FFC. That's the simple answer. Slightly extended version of that answer is, say, for instance, we have a company, a trust, something like that, an entity, a juristic entity that owns property, and you are a trustee, a director, a shareholder. You are in a position where this company is not a third party entity. It is part of you. It's yours, and it's not a listed company. It's a private company or a family trust, something like that. And you've always just done the rentals on behalf of that particular entity, you are not receiving remuneration specifically for the task that you are fulfilling in managing the property on behalf of the entity, then you are still not seen as a property practitioner and you don't need an FFC. However, if you are acting on behalf of a third party and you receive remuneration, typically in the form of commission, you're a property practitioner and you need an FFC. And I think that's brilliant because there's been so many people out there that wasn't registered estate agents and they sweep the commission out of under the estate agents that go through all the effort of doing it right. So I'm very excited about the PPA, and I think that was a long, short question. A long, short answer.
Oh, no worries, Cilna. There are lots of questions coming your way. We're going to try and pile in as many as we can while we have you with us, especially in a live forum like this. So a question that comes up quite regularly, does a tenant have the right to complain to the property owner if the individual is not maintaining the property?
Well, anybody can complain about anything, right, Ryan? But whether that complaint is going to fly or have an effect is the question, I suppose. So, yes, to look at a situation where a landlord doesn't maintain a property. Remember, if we look at the Rental Housing Act and the moratorium that we have in the Rental Housing Tribunal, the moratorium I'm talking about is if you have a claim, active claim in the tribunal, and it is not resolved within a period of 3 months or until it's resolved, you're not allowed to approach a court with a similar action. So there's a moratorium that is sitting there, and that is why I always say, please don't try and get an eviction from the tribunal. They don't have the jurisdiction. And on top of that, you're creating a moratorium, which means we're going to have to wait 3 months until we can commence in an actual court. But my point with this is that moratorium is not there unless in a situation where there is rent or maintenance outstanding. So why I'm saying this is the way the Act views maintenance obligation of the landlord is 100% exactly the same as the Act views payment of rent. So we all know how we can jump up and down when a tenant doesn't pay rent. The same level of up and down jumping, which is probably complaining, the tenant may do if the landlord's not doing maintenance. Now, this will depend on your lease agreement on how to handle it. If you have a lease agreement that does refer to breach on behalf of the landlord, then you would be able to place the landlord on terms, give him a time period to remedy his breach, and then act accordingly, either by cancelling the agreement, enforcing specific performance, or using I'm putting my face like this because I didn't expect myself to throw Latin here. You're going to use the exceptio non ademptati contractus remedy, which says a party where one of the parties is in breach of the agreement, the other party may place the party in breach in mora. So you do a letter of demand, you give him a time period to remedy. And if he doesn't, you may then withhold performance until the other party performs. So I'm never saying a tenant may withhold rent when the landlord doesn't do maintenance. I'm saying the tenant may withhold rent until the landlord does maintenance if the correct legal process is followed. And other option is obviously to go to the tribunal and compel the landlord to attend to the necessary maintenance.
Okay, so speaking of landlords, Cilna, can the landlord put up the rent by any amount that he or she wants to?
Okay, so there are different scenarios. Obviously, our annual escalations are agreed to in terms of the lease agreement. And now I'm going to answer a question that you didn't ask. What happens if we don't agree to a specific amount or a percentage annual escalation? That's quite dangerous. And I must say, one of my biggest things that makes me sad is if you have in your annual escalation clause recorded as to be negotiated. The truth is, at the time of conclusion of your lease agreement way back when, all the parties loved each other. The property was the most amazing thing you've ever seen. The tenant was a lovely person. But by the time we get to renewal, somewhere somebody sort of forgot to do maintenance. The tenant that one time pulled out that one plant that the landlord really loves, and now the relationship isn't as moonshine and roses as it was at conclusion of the agreement. Now we have to negotiate around an annual escalation. Parties aren't coming to the party, and they struggle to find the annual escalation percentage. So please make sure at the time of conclusion you record it. Those escalations, obviously, we do them annually in terms of your lease agreement. Other rental escalation, the unfair practice regulations does allow a landlord to increase the rent midterm, provided that he notifies the tenant of such increase on 2 months' notice. So most lease agreements, and specifically, for instance, the TPN leaseback lease that I'm one of the drafting attorneys of, we have a clause in there that upsets people on a next level, that says that a landlord may increase the rent in a case where the levies or rates and taxes increase. The thing is, the Act does allow for this, and the fact that the lease agreement caters for that simply secures the position for the landlord, and it avoids the situation of a massive fight. Because Section 2 of the Rental Housing Act specifically says that government has to do everything in its power to encourage and stimulate the rental market. Obviously, part of our housing crisis will be resolved by proper rental property, coming back to my passion about the rental industry. But we need to make sure that our landlords maintain a proper return on investment. If we feel more for the tenant and we put ourselves in the tenant's shoes constantly, saying like, oh, it doesn't feel fair that my rent increased because rates and taxes or levies increase, it means the landlord has a lower yield, which means he's going to take his money. He's going to buy Bitcoin and be a very sad panda today. But I had to make a Bitcoin joke. I knew it's going to pop up. But so for us in the rental industry, we need to make sure that we give landlords the level of security that they need. So they rather put the money into rental properties, which we can rent out, and then also deal with the housing problem. But it does mean that the tenant might have to pay higher rent. So in those cases, he may increase. Random, reasonable, and no reason why we are doing a sudden increase, definitely not allowed, unless the lease agreement caters for that. And to be quite honest, I can't see a situation where a tenant will in advance agree to random increases of rent. And those are the landlords we don't want to motivate. But the legal ones that stick to the law, more than welcome. And if your lease agreement allows for it, you can increase if rates and taxes increase.
So I seem to get the understanding that landlords seem to be quite a hot topic. So what can a landlord, or is there anything specific that a landlord can use the deposit for?
Yes. Please never ever use a deposit during the subsistence of the lease. So what happened is, I don't know if you guys remember this, but 2020, we had a hard lockdown. And I think we all still remember it vividly. But nobody had there was no money moving. People couldn't work. 26th of March 2020, the doors closed like the doors of the ark. And we couldn't get out. And we had to use quite creative situations to just keep the money flowing, to allow the landlord to pay his bond, rates and taxes, those kind of things. And in those extreme circumstances, which I really hope that we don't see again in our lifetime, but in those extreme situations, we did allow. I drafted the agreements, and I do suppose most of the people watching this actually know exactly what I'm talking about. Did this rent recovery agreement with TPN, together with TPN, and we did a deposit utilization agreement. But somewhere in that, people got confused and decided we can use the deposit randomly as we please midterm. That was not the intention. It was a crisis, absolute pandemic drama, problem solved. But now we're out of it, and life is much better and more calm. So in normal life, don't touch the deposit while the lease agreement is running. You will see that the Act specifically says that the landlord may utilize the deposit at the end of the lease agreement. And the way I draft the TPN leaseback lease as well is I always say at the end of the lease agreement. So at on cancellation or termination of the agreement, then you may utilize it. What we did in the context of the deposit utilization in pandemic vibes was actually agreed that the tenant will no longer pay a deposit. So the landlord released the deposit. The landlord said, okay, cool, I don't want the deposit, released it to the tenant, and the tenant paid his rent with that. So it's not something that we use during the subsistence of the lease. The Act doesn't allow for it, and we can only utilize it at the end of the lease only for things that damages that were caused to the problem, to the premises during the subsistence of the lease. So you do a proper incoming inspection, proper exit inspection, and the damage that you can prove was caused by the tenant. To repair those, you use the deposit, and any amount due in terms of the lease agreement, you can deduct from the deposit at the end of the lease. So a rear rental, arrear utilities, whatever, anything in terms of that agreement that is unpaid, you may use the deposit for at the end of the lease agreement. But please make sure when you utilize the deposit, it's important to be aware of the fact if you use the deposit for fixing things that were broken or whatever by the tenant does not have the right to say, which contractor the landlord must use. A tenant doesn't have the right to see 3 quotes and then pick a quote. It's not an insurance claim, it's a rental deposit. The Act simply says that if we utilize deposit money for repairs of things that were discovered during the exit inspection, damages that were discovered during the exit inspection, the landlord only has to provide the tenant with receipts for the work done. So the Act doesn't even say you have to see the invoice and everything, it's just a receipt. So it's very important to be aware of that. And there is a rumor going around that you can't use the deposit for a rear rental. That is a very interesting rumor. Most definitely at the end of the lease agreement, after you've done the calculations of the damage to the property, I would normally advise that you allocate deposit money to damages first and then a rear rental later. And if the deposit wasn't enough to cover that, at least the claim that you then have is an arrear rental claim. And why I'm advising that is the burden of proof is much lower on a rental claim, because why? You show the lease agreement. This was the rent that he paid. No, okay, there's it. You've proved your claim, and you can do those through the tribunal. So a quick, easy claim where to prove damages and the cost of that. You're going to have to get some experts, and it's a more messy process. It can be done, but it's easier to claim rent.
Okay, so as soon as we're talking about payments and money, can a tenant refuse to pay the electricity user fees implemented by council?
Yes, if the lease agreement's not drafted properly. So your lease agreement, yellow. If I start saying yellow, then this one is very close to my heart. The thing that makes me sad and keeps me awake at night is the fact that people have this interesting idea that we want short, quick lease agreements. And the thing that makes me very sad is if I hear somebody saying, no, but I always use this little 2-pager. It's easy. Everybody understands what's going on. Yes, okay. The essentiality of a lease agreement, so what makes a lease agreement is the agreement between the parties that the tenant will have undisturbed use and enjoyment of the premises. The tenant will pay rent, and this arrangement will be temporary. So if we have those terms in the agreement, yes, it's a lease agreement and it does tick the boxes. But it ticks so few of the boxes that I would rather than just go for a verbal agreement and have the common law govern this thing. Please don't go for verbal agreements. Cilna Steyn did not say go for verbal agreements. Cilna Steyn said go for verbal agreements rather than having a silly 1-pager. A properly drafted lease agreement, residential lease agreement, is about 17 to 20 pages long, where a properly drafted commercial lease agreement is more in the region of about 50 to 65 pages. The reason for this is a lease agreement is the basis of the relationship between the parties. And if your lease agreement isn't clear on absolutely everything that the parties agree to, you do have a massive problem. So everything that must be paid or shouldn't be paid must be recorded in the lease agreement. If it's not, you probably won't be able to claim it. So in the clause dealing with utility payment, if there isn't a specific provision that the tenant will pay for the connection charge, the service connection charge, then you won't be able to claim it. Well, that was so many words in one. You won't be able to claim that then from the tenant. The landlord would then only be able to claim reimbursement of the actual usage. So make sure your lease agreement is properly drafted and does contain that provision. So again, very long answer. But if your lease agreement's properly drafted, then yes, you can. Otherwise, definitely not. The connection charge you won't be able to claim from the tenant. But if drafted correctly, you can most definitely claim it.
Thanks, Cilna. Don't worry about the length of your answers. I think it's very important that the specifics are mentioned because, of course, it can be a bit of a grey area. So that was a question from Olga. So I'm actually going to ask you a live question here from Aurelia.
Yay.
Do leases supersede a sale? In other words, if you have a lease and the seller wants to sell, will the lease take precedent?
Oh, I love it. Yes, it will. It always will. That principle is called hier gaat verkoop. And what hier gaat verkoop, remember our law is based on Roman Dutch law, and this is why it's a Dutch law term. You can clearly hear it's Dutch. And thank goodness I'm Afrikaans, so I can say hier gaat verkoop without having my tongue twist in all sorts of ways. So what that principle means is if you have a lease agreement and you sell the property, the lease agreement will remain in place. Okay, now I am going to give a very long answer. So you guys will have to get your pens and paper out now, because now I am going to give you a very proper law lecture. It starts with the understanding of the law of around the right of ownership. The right of ownership is a very complex right. I think I'm one of the few right-brained lawyers in South Africa. But with my little lawyer brain, it's actually quite interesting because I can see this right in a picture. I actually have an article on this on my website. You guys are more than welcome to go and read it. It's got an image of a bouquet of flowers, and I'll explain why now. The right of ownership isn't one thing. It's not like, yes, the right of ownership. It's a complex right. It's a very, very complex right that contains multiple different rights. So I always explain it at the hand of a bouquet of flowers. And it's like it's close to Mother's Day, so I can use Mother's Day flowers as an example. Say, for instance, you knew you're going to take your mum for lunch on Mother's Day, but you forgot to get flowers. So now you're stopping at the closest garage. Garage flowers is what I'm talking about here. You know those garage bouquets? You will never get only roses. It's like a bunch of different flowers. And as you head to the dinner, you realize your sister is going to be there as well. She's also a mother. You need to make a plan here. So you take one of the gerberas or roses or whatever out of the bouquet of flowers, you stick it on a chocolate, and you're like, sister, happy Mother's Day to you too. And it's actually the same bouquet. Why this is relevant is the right of ownership is like that crazy bouquet with all sorts of different rights and flowers now. And every one of those rights can be handled separately. The rights that form this right of ownership, for instance, include the right to sell the property, the right to use the property as security for a loan, the right to destroy the property, obviously within reasonable limitations. If you have a third floor unit on a 7-story building, please don't destroy your unit. So within reasonable limits, and to trade with the property as you want. But one of the rights that stand out is the right of occupation. He isn't a separate right to the right of ownership. He forms part of the right of ownership. So he's that rose that you now gave to your sister. So still keep that in mind. You have the full right of ownership. This is the full bouquet of flowers. And then you have this one that you gave away, and you gave it away to the tenant, the right of occupation, in return for payment of that. Now, when you sell the property, you are selling the full collection of the right of ownership. But because this personal right The right of ownership is a real right. A real right means it's a right that attaches to a thing. We know this right is protected by Section 25 of the Constitution. But then the right of occupation is a personal right that attaches to a person, so your tenant. So as soon as the property is sold, on transfer, the purchaser becomes the landlord. We don't have to do an addendum, no, nothing. It happens ex lege by way of law. On transfer, the seller steps away and the purchaser steps into the shoes of the landlord. And even if we have to do an eviction later, with that lease agreement with the seller as the landlord, we will just explain to the court and we'll attach a deed search. It's that real in law. So then only when that lease ends will the right of occupation return to the purchaser. So no longer to the seller, but to the purchaser. Important in this, even though that personal right is a strong right and is protected by Section 26 of the Constitution by saying no person may be evicted from their property or have their property demolished without a court ordering to do so after the relevant circumstances has been taken into consideration. It's a strong protection of that personal right. And the reason for that is because of the weight of the right of ownership, Constitution had to bring in a bit of extra weight on the right of occupation. So important in this, we do have Section 4, subsection 5, subsection C, Section 4, 5C of the Rental Housing Act that says a landlord may cancel a lease agreement midterm on two provisions. First, it has to be in the lease agreement. So if your lease agreement is silent on that, you can't cancel the agreement midterm. And two, as long as the reason for the cancellation isn't an unfair practice. So you're not canceling because you can get higher rent from another tenant or something like that. And I specifically specify in the agreement I draft for everybody that the only two reasons that I feel comfortable with that does not constitute an unfair practice is when a landlord wants to sell the property or take possession of the property himself. It's not in contravention of anything. It's not in contradiction to the principle of huurgaatverkoop. It's actually an extension of that. Because say, for instance, you have a purchaser that does want to occupy the property. He's actually cool with the situation. He's fine at the moment at the signature of the OTP that the tenant can be in the property. But then later things happen. It turns out the transfer and the bond registration was too expensive and he has to take occupation. That same right recorded in the lease agreement for the seller will now carry over to the purchaser, and the purchaser can enforce that and cancel the agreement in terms of Section 45C. That was a long answer, but so huurgaatverkoop will apply. Lease agreement will remain in place. But when you apply Section 45C of the Rental Housing Act, a landlord may, when done correctly, cancel an agreement to be able to sell a property. I do believe we might see, sadly, quite a few of those now with the interest rates coming back to where it should be. I think a lot of people that bought second properties with the nice, pleasant, low interest rates might have to sell, and there are tenants in place. So please be aware of this, but we can't cancel if the lease agreement doesn't allow for it.
Excellent, Cilna. I think that covered everything that I really asked there. I have another one. So Penny Deckenau wants to know, we have a tenant who has been given 2 months' notice. However, she has not responded to her notice by email, and she's read the WhatsApp. So she's got the two famous blue ticks, requesting her to please read her email.
Okay.
What now?
I suppose notice, the only problem there for me, Ryan, notice can either be the notice in terms of Section 14 of the CPA, so your 40 to 80 business days prior to the impending expiration date, telling the tenant that they have to, that the lease agreement will terminate. I'm guessing it's not that one. So only other option would be a breach letter, but that wouldn't be a notice per se. So let's take, I do think you're referring to a letter of demand. I'm quite sure. So remember, we can't, because a tenant doesn't pay rent, and I'm making a million assumptions now, but if a tenant's not paying rent, we can't give them notice to terminate the agreement, we need to follow Section 14 of the CPA. So you need to give him 20 business days to remedy his breach before you can cancel. But then on cancellation, but let me stop myself quickly. If the tenant does remedy his breach, so he does pay his rent, we can't cancel the agreement. But if he doesn't pay his rent in full, we can cancel. But then we need to cancel with immediate effect. So we cancel and we say, you need to vacate the property immediately. Why? Because if we cancel the agreement and we allow him a further time period to occupy, say you can move out in a month or whatever, we create a new right of occupation. And the poor eviction attorneys on the other side need to deal with that first before we can commence with the eviction. So my advice is always stick to the normal rules. I have seen people do letters of demand that says you need to pay your arrear rental in 7 days. If not, you have a 20-day cancellation period. That's not correct in law. The CPA specifically requires us a clear 20 business days time period for the tenant to remedy his breach. Only if he doesn't can you cancel. But then, like I said, the cancellation is effective immediately, and you need to demand that the tenant vacate immediately. If he can't, it's cool. If he says, I'll vacate by the weekend, just make sure you record that in writing. If he says he'll vacate at the end of the month, please first make contact with us. So we put it in proper writing, because if he doesn't, to try and convince the court that this guy agreed to vacate, and the eviction must be a bit more quick, it's not going to fly. So just make sure that's done correctly. But I think the question is more, what about a notice that is not properly received? In terms of your notices and communications clause, so I don't know all your lease agreements, but I know some of you are using the lease back lease. So in terms of your lease agreement, you'll have a proper notice clause that says it must be sent to this email address or this postal address, please no. But let's say email address, and then they must be deemed receipt. So for instance, I always say an email or a fax. Remember in the old days of faxes, an email will be deemed to be received on the same day as dispatch. And then I don't do clever lawyer things that bite my clients in the face, because I don't require something like a read receipt will be sufficient. I just say it is deemed to be receipt on date of dispatch. So if you send it in terms of a lease agreement that contains a clause like that, whether they acknowledge it or not is irrelevant. So if they then don't comply with your notice, whatever your notice was, if they then don't comply with that, we can proceed as if they have acknowledged it. So as long as your notice clause doesn't say anything about acknowledgement, which I really hope it doesn't, or your notice. I very often see notices that says kind of confirm receipt of same. That's silly, because not silly, I don't mean like nasty silly, but it's a little silly because nobody is going to acknowledge that, and then you left out in the open about, was it now received or not. So just stick to the notices clause, and then with regardless of whether they acknowledge receipt or not, it should be proper service. And if you really struggle, if your lease agreement is your lease agreement doesn't contain a notice clause like that with a very clear receipt, deemed receipt time, I would suggest that you send the sheriff, because when all else fails, we have to deliver by sheriff so we can get a return of service and prove that it was in fact delivered. But let's try and avoid that, and we can avoid it easily by a notices clause in a lease agreement.
Okay, Cilna, so let's go over to sort of landlords, homeowners, and body corporates. And this is the last question I'm going to throw at you this morning. Can landlords make the tenants pay for fines issued for tenants' behavior by a homeowner association or a body corporate?
Oh, yay. I'm just getting the best questions. I'm so sad when you said it's the last one, because I'm having so much fun with your questions. Guys, quickly sneak in a few extra questions. I still have some answers in me. So yes, most definitely, but potentially definitely not. Okay, so here's the answer. Section 5(8) of the Rental Housing Act says that if there are any specific rules applicable to the particular lease agreement, if a copy of the rules are physically attached to the lease agreement, those rules will apply to the tenant. However, if it's not, it will not be enforceable against the tenant. And I have seen creative drafting in lease agreements. For instance, uh, the tenant will acquaint himself with the conduct rules, and he undertakes that he will adhere to them. That's not sufficient compliance with the Act. And remember, we can't contract out of legislation. So if the Act says it has to be attached, we can jump up and down. We can think it's silly. It doesn't matter. It's like there's a lot of things in law that we think, really, is this necessary? For instance, paying tax. Why is this necessary? But we still need to do it. So it's exactly the same. Even if you don't agree with Section 5.8, sadly, we have to comply with the law and we have to comply with legislation in full. So if you have a copy of the conduct rules attached, physically attached to the lease agreement, and the tenant is fined in terms of the conduct rules, then most definitely the landlord can pass those on straight to the tenant. If not, sadly, the landlord wouldn't even be able to place the tenant on terms for non-compliance with the conduct rules. We have done many evictions in SSLR on the back of non-compliance with conduct rules. You know, that tenant that always parks on the visitors' parking, or they are loud and they party until 3 in the morning. I don't know at my age how people do that anymore, but so those tenants that does things like that, not complying with the conduct rules, if you have it attached, you can place them on terms like you would for non-payment of rent or any other breach. Give them 20 business days to remedy their breach. And if they do it again, but obviously this is now not a standard letter of demand, this is a very specific drafted letter of demand. If they then don't comply at a later stage, we can cancel and we can commence eviction. However, if it's not attached, we can't. So attachment currently is different to what it was a few years ago. I think COVID helped us quite a bit on moving our lease agreements to a more digital situation. I mean, 2019 still, we wouldn't have seen as many digitally signed lease agreements as we currently see. Why this is relevant is in the old days when we still had to print everything and hand sign, it was definitely a requirement to have the conduct rules printed out and physically attached to the lease agreement. Where currently I am more than happy that it's compliance with the Act to make reference to the conduct rules in your lease agreement and attach it as an attachment to the email where you'd send the tenant the original lease agreement, or if you are using something like DigiSign from TPN or a similar system, obviously you just attach it as an attachment to the lease. It's safe, it's recorded, it's timestamped, and yay for digital technology.
Cilna, I think you talk about 3 o'clock in the morning. The amount of questions that are flying in here, you might be here till 3 o'clock in the morning answering the questions. Cilna, yeah, so just for all those that are asking questions, just please, this will be on our Facebook page and our YouTube page, and when we get to it, if we can get to it, we'll definitely answer it for you. Cilna, I want to, before we end off, I just want to tell the network and all those that have joined us today that we are very fortunate to collab with you over the next couple of months. We have some very cool modules that Cilna will be training and going through with us on our Remax Hub. So, Cilna, without giving too much away, just let's touch a little bit on what we can expect in those videos.
Oh, Yela, I'm so excited about that. Well, I don't think anybody can expect anything other than what you've just had. I will never be able to do normal lawyer training, and I think it's just my personality that can't go into. You know, I'm sorry, guys. I can't lawyer for anybody. I'm really, really sorry you get this every time. So you get this, but on specific topics. And we broke it up into modules. What you do get, however, is a slideshow, which is not something that you easily get from me. I usually just sort of talk off on the fly and like off the cuff, and I prefer those kind of things like this where I just get questions and I can answer, but it's a bit more structured and with slideshows and a lot of reference to the boring law stuff, because let's be fair, if we know the boring law stuff, if you can answer, let's say for instance you sit in front of a landlord and the landlord wants to cancel the lease agreement midterm. If you can say, Mr. Landlord, okay, like in terms of Section 45C of the Rental Housing Act, this is the position. Suddenly, landlords look at you differently. And remember, you're mandated by that person. And if he can show you understand the legalities behind what you're doing on his behalf, you are going to have a much easier way of navigating your way through the landlord-tenant relationship. If a tenant is moaning about having to replace a globe, and you can say, you know what, actually, it's in terms of Regulation 6.2 of the Unfair Practices Regulations, suddenly the arguments go away. If you can copy and paste legislation to a person, takes the fights away. So I think my intention with the trainings that we've recorded, and I'm really excited about it, I think it looks amazing, is very, very, very practical. I don't want to show you guys how clever I am. My mum is proud of me as it is. I want to give you practical things to do. I don't want to teach you about the law per se, but I want you to be able to know exactly where to go when you have a problem. Because my biggest thing in life is I am doing my absolute best to keep people out of the tribunal and out of court. And every time I say things like that, I know people wonder if I'm actually an attorney. I promise I am. But SSLR is an actual law firm that actually litigates, but we litigate when it's necessary and only for the important things. People very often fall into the trap of litigation. It ends up being drawn out for years. And I don't think people are warned in advance about litigation fatigue. A year down the line, you're not as passionate about this claim anymore because now you've had to do the 15th affidavit. You're so tired of all of this. So we try to avoid that. We have to go to court for an eviction. That's the one thing that you have to go through a court for. Any other form of evictions are illegal, like I said, in terms of Section 26 of the Constitution. So I think the focus of the training is practically taking those horrible calls and WhatsApps that you guys receive. I think rental agents, I say this very often, I think the biggest problem with rental agents is you guys are too nice. You will do things far out of your mandate to try and keep the landlord happy or the tenant happy. And it's those things that we end up saying no good deed ever goes unpunished. And I think rental agents, guys, really, I respect you so much, because you are willing to jump through hoops that I don't think a lot of other people are willing to jump through. But I'm just trying to make sure that those hoops aren't on fire and you're not a circus tiger. So we just keep you on the safe side of the law, so it doesn't cause harm to you. Is that a long explanation? I think we should call the training sessions, Ryan, maybe the let's put the fire out on the hoops thing, something like that. I thought my circus analogy now was on point for rental agents.
No, I think you've absolutely been on point, and you can see with the comments coming in, Bia said it's mind-blowing and insightful information. And the thing is that this is just the tip of the iceberg in terms of what we're going to be offering on our Remax Hub, in terms of the modules we're going to be going through, that our Remax network will have access to you. And that is absolutely incredible. So a massive thanks from our side here at Remax SA, Cilna. It's been amazing having you. And I think this needs to be, wouldn't say a regular thing, but I think we need to meet up again, maybe halfway through the training and the modules, and have this Q&A again. It's nice and informal, and also there are loads of questions being fed by our network, and just the way you answer it, so precise and so specific. And even when you have to use Latin, it's still, the information provided is just absolutely incredible. So thank you so much. And I want to say a big thanks also to our Remax network for joining us today. It's been incredible having you here. And this is going to be on our Facebook page, on our YouTube page, so please feel free to share. And again, if you have any questions, just pop them in the comments there and we will go through it. and we'll obviously try and answer as many as we can when we can. Cilna Steyn, it's Friday. Have the most amazing weekend.
Thank you. Thank you so much, Ryan. You're saying thank you to everybody. So I want to say thank you to you. Thank you for putting it all together, for working hours and hours and hours to make those training videos look amazing. I think you make me look 15 times more clever. My mum is going to thank you too. But so on behalf of me and my mum and the rest of the SSLR team, thank you so much for what you're doing. And I think for the Remax team, I think bringing very specific rental training in, I think is absolutely wonderful. So thank you, Ryan. And thank you, Team Remax.
Thank you, Cilna. Absolute pleasure. And as passionate as you are, I'm exactly the same way, as passionate as I am when it comes to training and just being there for our network. So thank you so much, everybody, for joining us. Thank you, Cilna. Have a lovely weekend, and we'll see you all soon.
Thank you. Bye-bye, everybody.
Bye-bye.